Hi, my name is Audra Platt. I'm one of the estate planning attorneys here at Pittman Law Office, and today I wanted to talk about the basics of estate planning. So I am going to go over your incapacity documents, the differences between a last will and testament and a revocable trust, and some of just what the documents mean, how they're used. So I'm really going to start from ground zero, and I want to start with our incapacity documents. So there's 4 of these, and I start with these documents because whether you have a will-based estate plan or a revocable trust-based estate plan, the incapacity documents come with both. So incapacity documents are there just in case you become incapacitated, who can act on your behalf. So let's start with power of attorney. Power of attorney is over the finances while you are alive. This is a very powerful document. It becomes effective the day you sign it. So the moment you sign it, it becomes a valid document. It is binding. Right then, your agent is able to work for you. Now, there are policies and procedures that institutions use to make it where they want to prove that there's something wrong with you. But legally, the power of attorney becomes effective when you sign it. You are saying that your agent can basically do whatever they need to do for you financially, except sign a will, legally vote, and sign you up for the military. So those 3 things are kind of the bigger ones. Of course, there's more things that they can't do for you. They do have a fiduciary duty to do what's in your best interest, but the power of attorney is over finances. So what can they do? They can sell your house, they can sell your car, they can move your money, spend your money, close credit cards, open credit cards, sign contracts on your behalf, finish payroll if you're a business owner. This is a very, very powerful document. So what that means is it's very important that you actually think about the person that you choose to be your agent named in the power of attorney, and make sure that you can, 1, communicate with them, and 2, that they'll actually follow through with what you need them to do. So I have a lot of clients that they're not really comfortable with giving all of their financial information to their agent, and that's fine. I'm not asking you to do that. But it is very important that if something happens to you, that your agent knows where your assets are. What are your expenses? How do they step into your shoes and keep your life going? Because really, if you get into a tragic accident and your agent needs to step up and work for you, and they have no idea where your money is or where your bills are or how many credit cards you have or where your homeowner's insurance is, they're going to be floundering, and it's going to make their job a lot harder. So it's important that you name the person that you trust, but also that you communicate, whether it's verbally or whether you just have a spot safe in your house that you have all of the information written down so then they can start working for you if something happens. Now, power of attorney dies with you. So when you pass away, your power of attorney passes away with you. It's no longer valid. And then we are relying on beneficiary designations, your last will and testament, or your revocable trust. So power of attorney, again, is over finances while you are alive. It's not just paying bills. It's also things like maybe being a guardian for you if needed, or filing a tax return, or making sure that your investments are still how they need to be. So power of attorney, big deal, over finances, starts when you sign it, dies when you pass away. The other 3 incapacity documents are really dealing with your medical and who can make medical decisions and who can gain your medical information. So I start with HIPAA. HIPAA is a document that says who the doctor can actually release your medical information to. So when you go to the doctor, you probably fill out a small little HIPAA form at the bottom, and if you're like me, you don't put everybody, you just put the next person next to you, right? Your husband, your spouse, your best friend, kid, whoever it is, and then you just keep on going because you're just trying to make it to the appointment. And that's good, and that's for that institution. But if something happens to you and you're rushed to a hospital that you've never been to, and we want to make sure that your loved ones can gain medical information for you, you need a HIPAA authorization. So our HIPAA authorization will cover basically as a blanket. They can take the HIPAA authorization in And anybody you have listed on the HIPAA authorization can get your medical information. So this is where we can really kind of think outside the box. You don't have to just put the people that you want actually making decisions. This is where you can put the people who will be there. Again, not just making decisions, but who will actually show up. So for me, I might not want, let's say, my brother-in-law actually making medical decisions for me, but I want him to be able to gain my medical information because I know if something happens to me, my sister's going to be there. I want to make sure that my brother-in-law can maybe drive to the different hospital, get my MRI results, pick them up, take them to my sister, right? So I'm not necessarily saying that I want him to make a medical decision, but I want him to gain my information. So again, this is where we can kind of be creative. If you live around here, maybe your kids live in another state, and you want to make sure that your neighbor that you've become very close with, if something happens, they can come to the hospital, get your information, call your kids, kind of be a conduit before your actual administrators are able to get to you by your side. So again, HIPAA is just medical information. You can list as many people on that document as you want, and they do not have to actually make medical decisions. It's just getting your information. The two documents that actually discuss making medical decisions is the living will and the designation of healthcare surrogate. So the living will sometimes gets confused with a DNR, a do not resuscitate. A DNR is a bright yellow document. It comes from your physician, and it says that you don't want CPR. Okay, so CPR, you fall down, you have a heart attack, is someone supposed to give you CPR? That is the document, or excuse me, the DNR is the document that covers CPR. The document that we do is a living will, and it focuses on life prolonging procedures. So this is where you're saying you do not want to be kept alive by artificial means. So you do not want a feeding tube, you do not want a ventilator. Now, in order for this document to actually be enforced, to actually work for you, there are a certain set of facts that actually have to be made, or you have to check the boxes before the living will can actually act. So you have to be incapacitated. Again, you can't be making your own decisions. If you are, then they're just going to listen to you. So you have to be incapacitated, and you have to be in one or more of 3 statutorily defined conditions. So you have to either have a terminal condition, an end stage condition, or you have to be in a persistent vegetative state. So one of those 3 or more. And 2 doctors have to agree that there is no chance of you recovering from the situation. So you have to be incapacitated in one of the 3 conditions, and 2 doctors have to agree there's no chance of recovery. If we have all of those prerequisites met, then the living will can be enforced, and the doctor can say, we meet all these prerequisites, it's time to enforce this, pull the ventilator or don't put the ventilator in, or no feeding tube, whatever the situation may be. But the living will is the one that says you don't want to be kept alive by a machine. Now, sometimes the questions aren't always that cut and dry, and there are situations where you need somebody to just advocate for you. Yes, make decisions, but also advocate for you. Ask the questions, poke, prod, be your bulldog. That authority comes in the designation of healthcare surrogate. So you are naming a surrogate in this designation of healthcare surrogate to advocate on your behalf. So this person, you have to make sure that you can communicate with them, that you can tell them what you want, and then also that that person will actually follow through with what you want. You want to make sure that this person can actually pull your plug if needed, but make sure that they can ask all the questions. Hey, we need a second opinion. We need a specialist. Don't give mom penicillin, she's allergic. Or we need to have a different type of doctor, or maybe a different blood panel. All of those type of decisions and questions and advocating comes with the designation of healthcare surrogate. This document, it doesn't tell your surrogate what to do. It just tells the doctor who they need to listen to on your behalf. So what that means is it's very, very important that you tell them what you want beforehand. I have had too many clients sitting in my office crying, remembering that they had to, what they went through when they had to make decisions for their parents or an aunt or a friend that did not communicate what they wanted. So they're just flying blind. They didn't know what type of decision to make, and they did the best that they could, but still they're living with maybe extra guilt that wasn't necessary. So make sure that you can communicate with the person that you name, and make sure that you actually communicate with them. Second opinions, specialists, blood transfusion, organ donation, nursing homes, all of that type of stuff needs to be discussed with the surrogate so then they can properly advocate for you. So kind of as a recap, our 4 incapacity documents, we talked about power of attorney, which is over your finances, your HIPAA authorization, which is information, your living will, which is pulling the plug, and the healthcare surrogate, which is the one that can be your advocate or your bulldog for you. So those 4 documents come with a last will and testament or a revocable trust. So that's why I started with those. But now I'll move over into the discussion of how do we get assets from a deceased person to their beneficiaries after they pass away. And there are 3 main tools that we use. We use a last will and testament, revocable trust, and beneficiary designations on financial accounts. So I'm going to start with a last will and testament. When we have a will-based estate plan, we use a combination of a will and beneficiary designations to try and avoid probate or reduce the length of probate, reduce the amount of time, and reduce the expense of probate. So with a last will and testament, you are giving the probate judge a rule book as to who you want your probate assets to go to when you pass away. So what is a probate asset? A probate asset is an asset that's in a dead person's name with no beneficiary. So what that means is that if you have a beneficiary on a bank account, a life insurance, an IRA, a 401k, and you pass away, that money will go to the named beneficiary without probate. Beneficiaries can sometimes be called POD, pay on death, or TOD, transfer on death. They're just all different names for beneficiary, but they avoid the probate process. Okay, so beneficiaries will keep an asset out of probate, and beneficiary designations supersede your will. So let me give you an example of what I mean by that. Your will might say, I want all of my probate assets to go to a charity, okay, St. Jude's. And on your bank account, you forgot to change the beneficiary from your ex-wife from 10 years ago. When you pass away, that beneficiary designation supersedes, which means that money will go to your ex-wife from 10 years ago when you pass away. Now, I use this example because it's real. I had a client come in, life insurance beneficiary designation was not changed on her late husband. They were married for over 30 years, and the life insurance policy went to the first wife that he was divorced over 40 years ago. So make sure that you are up to date on your beneficiary designations because it matters. So let's take an example of a last will and testament. So individual client comes in, has 2 children. Individual client passes away. They have beneficiaries on all of her bank accounts. And when she passes away, the only asset that goes through probate is her homestead property. She's giving her homestead property to her 2 daughters, her legal heirs, which means the probate process is typically 90 days or less and costs somewhere around $4,000. So after the 90 days, the judge issues an order that shows ownership of the home. So both daughters, 50-50 ownership. Then they put the house on the market, and during this time that they are waiting, all of the bills still have to be paid. So if deceased client had a mortgage, insurance, taxes, utilities, lawn maintenance, pool maintenance, house cleaning, all of those bills still need to be paid to keep the house in working order so then when it's sold, it's ready to go. So let's say that one of the daughters pays all the bills. At the end of the day, when the house is sold, the new purchaser is going to have checks for 50-50 each daughter because that's how they own the home. The daughter that paid the bills is then going to go to the other sister and say, hey, will you please pay me back? And that sister can either say yes or no. It is up to that sister. So there's no way that I can make, in this situation that I'm giving you, the one sister pay back the sister that paid all the money and paid all the bills. So family dynamics plays a huge role in which estate plan is best for you. Also, the type of asset that you have. If this is a secondary home, not your not your primary residence, and you want to give this house to the two daughters, if it's your secondary home, it will go through a formal probate process, which is a lot longer and it costs a lot more money. So when you come into Pittman Law Office, we look at you as a whole. We look at your family dynamics. We look at, do your kids get along? We look at how many homes do you have? We really don't care the exact dollar amount of how much money you have. Now, of course, we think about that. We look at that for tax purposes and everything. But really, we're using that information to just try and make sure that we get you the right estate plan that works best for your family. So when you have a last will and testament, you own a home, your house will go through the probate process. Again, your will is a rule book that's given to the probate judge that dictates where your probate assets go to. Now, if you want to avoid probate at all costs, then we can talk to you about a revocable trust. A revocable trust is a great tool that we use to not just avoid probate, but to also make it as easy as possible on your administrators after you pass. So let's take that situation and let's put people in it. So my mom, widowed, two daughters, 50-50, and I'm the trustee. Okay, so mom dies, and if she funds her trust properly, funding your trust is where you connect your assets to the trust, okay, or put money into the trust. Now, the type of trust that I'm talking about is called a revocable trust. Revocable means it's changeable. It means that the owner stays in control. It means the owner can spend all the money that's in the trust. They can disinherit people. They can change beneficiaries. They can do whatever they want. The owner is in control. But when the owner passes away, the trust becomes irrevocable, which means it can't be changed anymore. So if mom came to Pittman Law Office, we would advise her to put her non-qualified money in the trust. This is money that you have already paid the income tax on. So put that money into the trust. So mom died, mom has checking accounts, savings accounts, a brokerage account into the trust. Me, as trustee, I have a fiduciary duty to do what's in the best interest of the beneficiaries, which means I can't take mom's money and go on vacation. But I have a duty to take that money that's in the trust and pay mom's bills. So taxes, utilities, insurance, mortgage, lawn maintenance, house staging, landscaping, new roof, whatever needs to be paid to get that house sold. So I am able to use mom's money that she put into the trust to pay those bills. Once all the bills are paid, the house is sold. The proceeds from the sale of the house goes back into the trust. Again, the trustee has a duty to do what's in the best interest of the beneficiaries, so paying all the bills, making sure everything's satisfied, and then once everything's done, then the trustee can split the assets 50-50. So what that revocable trust did is it avoided the probate process, but it also made it where the administrator, the trustee, didn't have to go to the other beneficiaries and ask for payment back. Before the money in the trust is ever split 50-50, the trustee is able to use it to pay the necessary bills. So that really is where the family dynamic part comes in. You're avoiding that process of trustee having to ask for money back, not having enough money, whatever the family dynamic situation is. So that is a really good thing about a revocable trust. Revocable trusts are not right for everybody. Okay, so we have a lot of people that come in that's like, I have to have a trust. Trusts are great. I have a trust, okay, but it's not necessary. Not everybody's facts makes it where they need a revocable trust. So I'm not dogging on wills. They are very, very good tools to use. It just really depends on family dynamics, the type of assets you have, and if you want to control the money after you pass away. So there are a couple trigger questions that we ask you when you come in that kind of guide us as to which estate plan might be best for you. A couple of the questions. How many pieces of property do you have? If you have more than one, typically it's more economical to do a revocable trust. Do you have minors? If yes, you likely need a trust. Do you want to give money to minors? So grandkids, great-grandkids. And do you want to control the money after you pass away? So if you say, all my people are of age, they just are terrible money managers, and you want to control the money after you pass, a revocable trust is a great tool to do that with. And also, is someone on Social Security disability or Social Security income? If they are and they come into a lump sum, sometimes it will kick them off of the government supplementation that they're getting, and we don't want to do that. So a revocable trust is a great tool as well. So this was the basics of estate planning, right? We talked about your incapacity documents before you pass away, and then the tools that we use after you pass to get your money from you to your beneficiaries. Now again, this is very high level, and I am a Florida licensed attorney, so this is Florida information, just education purposes. We have a ton of resources on our YouTube channel and on our website, and we do free consultations here at Pittman Law Office. So if you are a Florida resident and you are interested in updating your plan or establishing an estate plan, we'd love to help you. When you come in and see us, we do ask you to fill out an intake form, so then when you come in and see us during that 1 hour, we can really get to the nitty-gritty and actually talk about you and what your goals are. Thank you. Again, my name is Audra Platt. Don't forget to check out our other social media platforms. Thank you.